بسم الله الرحمن الرحيم الحمد لله وحده والصلاة والسلام على من لا نبي بعده وبعد. Assalamu alaikum wa rahmatullahi wa barakatuh. So this is the final session in what has been the Advanced Usul Fiqh study course with the Legacy Institute in the specific topics regarding Ijtihad and Taqlid and associated issues. And when we began this course, because it was the first time I'm delivering this, I didn't have much of an idea as to how many lessons it would take me. So thankfully, I've only been off by around 1 or 2 lessons. I gave an extra lesson on the Sunday last, and this is the final lesson. So, I mean, it really depends on the teacher, what level of depth he or she wants to go into. We could have so easily stretched this to 30 or 40 lessons. We did quite a bit of reading towards the beginning, up to halfway, but it eventually transpired that if we just kept on reading from the original sources, then most definitely the course would have to be extended to around 40 or 50 lessons. So and each lesson was around 1.5 hours to 2 hours long. So قدر الله ما شاء. So this final lesson, we've made it open access, so anybody who wasn't on the course gets a flavor as to what type of issues were discussed. But this lesson nonetheless is still primarily targeted at those who subscribe to the course and have been there from the beginning, and discussions within this will remain of an advanced nature. Towards the end there will be opportunity for Q&A, but feel free to put it in the chat, whether you're on Facebook or watching on YouTube. And also there'll be an introduction to the forthcoming course, which I believe starts this Saturday, and that is a condensed version of this course targeted at those who are interested in the subject without having fulfilled the prerequisites of the advanced course. So those who don't have knowledge of Arabic or have studied fiqh or usul at an advanced level, they would be able to access the concepts of Ijtihad and Taqlid that we're discussing this course in that course, and that starts on Saturday, which I'll discuss in a moment. So to start off today's lesson, so Ibn Taymiyyah said in his Al-Hisbah that وَأَمَّا أَهْلُ الْكِتَابِ فَمُتَّفِقُونَ عَلَى الْجَزَاءِ بَعْدَ الْمَوْتِ وَلَكِنَّ الْجَزَاءَ فِي الدُّنْيَا مُتَّفَقٌ عَلَيْهِ مِنْ أَهْلِ الْأَرْضِ فإن الناس لم يتنازعوا في أن عاقبة الظلم وخيمة وعاقبة العدل كريمة، ولهذا يروى الله ينصر الدولة العادلة وإن كانت كافرة ولا ينصر الدولة الظالمة وإن كانت مؤمنة. And this is a basic fact in human life, that wherever there is justice, those societies would prevail, and wherever there's injustice, those societies would not prevail. So Allah subhanahu wa ta'ala sent down his sharia for the Muslimin, for the mu'mineen, to implement within this land, whether that's in relation to themselves in matters of rituals, ibadat, or whether that's in relation to transactions, mu'amalat, or whether that's in relation to ahwal shakhsiyya, such as nikah and talaq, marriage and divorce. But Islamic law isn't the only legal system that is acknowledged by Islam. What do I mean by that? Non-Muslim societies also have their own legal systems, which we'll discuss in the next slide. And so, for example, if in a Muslim state there are a couple, Christian couple or a Jewish couple or a couple of any other religion other than Islam, and they want to get married according to their laws, the Islamic State would recognize that marriage as a valid marriage, even though they might not have married according to Islamic law per se. And in societies where laws are upheld, even if they're not Islamic in nature, but there is a degree of justice, then Islam recognizes that as a valid form of justice dispensation. And that is why Ibn Taymiyyah says something really interesting here, that Allahu yansur dawlat al-adilata wa in kanat kafira wa la yansur dawlat al-zalimata wa in kanat mu'mina, that Allah assists a just state even if it is a non-Muslim state, whereas Allah would not assist an unjust state even if it's a supposedly Muslim state. Because the Prophet ﷺ said, "Al-dhulmu dhulumatun yawm al-qiyamah," that injustice will come in the form of layers of darkness on the day of judgment. So that sin is separate from any potential sin associated with polytheism or disbelief or any other sin. So dhulm in and of itself is a sin in its own right, which carries its own terrible consequences, both in this world and in the hereafter. And the concept of justice is recognized across all religions, and even of those people who don't have a religion. And that is why even in today's modern nation-state society, those states that have a strong sense of justice and fairness, those states prosper relatively more to those other countries where there is a perception that justice is not done. So, for example, if you look at the state of businesses and where they decide to place their headquarters, I mean, one of the considerations they might have is that where the lowest taxes are. Okay. Another consideration is the sense of stability and the sense of fairness and the sense of predictability within the justice system. So, if a multinational corporation wants to place its headquarters somewhere, they wouldn't put it in some banana republic where they don't know how the authorities there would treat them. They would, and even if there is a sense of any unfairness, they'll just move out straight away. So there is a purpose to court systems, regardless of whether they might be Islamic or non-Islamic. And Ibn Abdul Barr in his At-Tamheed reports a consensus of the Muslims, of the fuqaha obviously, who say that if a non-Muslim couple decide to marry according to their laws, which might not be valid in Islamic law, then they decide to accept Islam together, then obviously the Muslim state would recognize their previous marriage as a valid one, and they would not need to renew their marriage upon their acceptance of Islam. Only in situations where the marriage itself is considered to be a completely invalid marriage, which is nikah batil. So, for example, some Zoroastrians, in ancient times at least, considered the marriage between a person and his aunt or a woman and her uncle to be valid. So, obviously, an Islamic state would annul that type of marriage. Or if in another system, foster brother and foster sister are allowed to be married. So if they become Muslim, then obviously the Muslim state would break up that marriage, because that would be a form of nikah batil. So justice in Islam is not only about fulfilling the rights of man, which is the main concept within secular states and secular legal systems, but Islam has the adage of fulfilling the rights of Allah as well. So obviously you have the concept of huquq al-ibad and the huququllah in Islam. And pertaining to this, the hadith in Sahih Muslim is that on the authority of Tamim al-Dari radiyallahu anhu, أن النبي صلى الله عليه وسلم قال الدين النصيحة قلنا لمن قال لله ولكتابه ولرسوله ولأئمة المسلمين وعامتهم. That Tamim al-Dari radiyallahu anhu reports that the Prophet sallallahu alaihi wasallam said that ad-deen an-nasiha. Now, it would be an injustice, so to speak, to translate both of these terms into English, because these two terms are so comprehensive in their meaning that any one word in English wouldn't do justice. But to simplify it, ad-deen is basically the religion of Islam, which encompasses all aspects of life. So not only the rituals, the ibadat, but also the muamalat and the muashara and ahwal shakhsiyah, from cradle to death. What is that? An-nasiha. So again, that is one of those terms which is all-encompassing in terms of its meaning, so it's difficult to translate, but it is translated as advice. But it'll become apparent when the Sahaba asked the Prophet ﷺ, what does that mean? So he said, قَالَ لِلَّهِ. The first on the list is النَّصِيحَ لِلَّهِ. Obviously, that translation wouldn't really say advice for Allah. It doesn't really sit. So the most appropriate explanation of an-nasiha in this context is to fulfill somebody's rights. And obviously, the right of Allah is that He has to be worshipped. وَحْدَهُ لَا شَرِيكَ لَهُ. وَلِكِتَابِهِ. And nasiha for His book, which is the Quran. Nasiha for His messenger, sallallahu alayhi wasallam. وَلِأَئِمَّةِ الْمُسْلِمِينَ. And for the rulers of the Muslims, and by rulers is not only the political rulers but also the scholarly class, وَعَامَّتِهِمْ, and for the rest of the Muslims. So as we've discussed earlier on in the course, there are two types of law in Islam. There's one, the definitive, the qat'iyat, and the debatable, which are the dhanniyat. So this dichotomy between the definitive and the debatable is not only, it's not restricted to fiqh, but it also transcends into other subjects of other Islamic disciplines. So in tafsir, you'll have some tafsirs that are qat'iyat, definitive, that is the only interpretation of the verse, and some tafsirs you'll have a dhanniyat. And likewise in aqidah, many aspects of aqidah are from the qat'iyat, which are definitive, whereas some aspects of aqidah are dhanniyat, in which scholars can differ over the finer details of some aspects of aqidah. And even the Sahaba radiallahu anhum differed over some aspects of aqidah as well. But in the context of fiqh, obviously you'll have the qat'iyat and the dhanniyat. So the qat'iyat are obviously the clear-cut rulings of the Quran and the Sunnah and the consensus of the Muslims, whereas the dhanniyat is where scholars have generally differed with one another. And in the first, which are the qat'iyat, there is no ijtihad or taqlid applicable. Rather, there's only ittiba'. And ijtihad and taqlid are only pertaining to dhanniyat, where there is a degree of analysis involved by jurists, and then they pass the verdict in the form of fatwa, and people follow them. Other jurists might issue another fatwa. So that would automatically fall into the dhanniyat category. So that is where ijtihad and taqlid are applicable. Because if there's a clear-cut nas of the Quran, then there is no ijtihad need, that you just follow whatever Allah said. وَأَقِيمُوا الصَّلَاةَ وَآتُوا الزَّكَاةَ. Establish prayer and give zakah. So that is from the qat'iyat. It's clear. It's a clear injunction within the Quran. وَأَحَلَّ اللَّهُ الْبَيْعَ وَحَرَّمَ الرِّبَى. Allah has made halal sale transactions, and He has forbidden usury or interest. Now that is the top level command from Allah, the details of which can be differed over. So the details would fall under the dhanniyat, but the top level detail, the top level law, which is the hill of bay' and the prohibition of riba, that would fall under qat'iyat. And we discussed that if some scholar, past or present, happens to do ijtihad within the qat'iyat, then more often than not, that would be because they aren't aware of the text from the Quran and Sunnah. And if they happen to arrive at a conclusion which is in conflict with the hadith, then obviously that would constitute as what is known in Arabic as zallatul alim, a mistake of a scholar. So other scholars should not follow them, and likewise the Muslims shouldn't follow him in that regard. And there are numerous statements from scholars in relation to the warning of following zallatul alim. Another aspect with regard to the dhanniyat is that the dichotomy between ijtihad and taqlid is something that transcends fiqh. So ijtihad and taqlid isn't only in fiqh. It's in tafsir as well, it's in aqidah as well, it's in the worldly disciplines as well, like medicine and engineering and economics. So you have people who are specialists and you have those who are non-specialists. So the specialists are at the cutting edge of determining whatever the ruling or the situation should be. And you have other people who simply follow them, because those other people might be specialists in other disciplines. And that is why it is important to have specialists within fiqh, within Islam, within the Islamic disciplines. So it isn't a requirement for all Muslims to become specialists in fiqh, because obviously fiqh can go into great depth, and to have every Muslim man or woman who are engaged in their own lives to engage with the Quran and Sunnah like scholars do, that's an unreasonable demand. And the Quran and the Sunnah or the Sharia itself wouldn't demand such things. So that would fall under taklif ma la yutaq, which is burdening people with which they are unable to with something which they are unable to carry out. So that is muhalun aqlan wa shar'an. It's logically and legally impossible. Given that is established, the scholars then discuss how does ijtihad manifest itself, and how does taqlid, or how should taqlid manifest itself. So these are logical discussions. The details of ijtihad and taqlid are rational and logical discussions. They're not wahi min Allah. Okay? Once it's established that ijtihad is an obligation on those who are able to do ijtihad, and taqlid is an obligation on those who aren't able to do ijtihad, because taqlid is a substitute to ijtihad, as we've established from Fatawa al-Alayan and Ibn Abdul Barr and others. So that once we've established that, then those who do ijtihad, they would go to the Quran and Sunnah. That is their proof, that is their hujjah. And those who do taqlid, they simply refer to scholars, and that is their proof. The Fatawa al-Muqallidin, al-Fatawa bin-nisbati lil-Muqallidin kal-adillati bin-nisbati lil-Mujtahidin, as Ash-Shatibi says, and others. So the Quran says in Surah At-Tawbah, Allah says, وَمَا كَانَ الْمُؤْمِنُونَ لِيَنْفِرُوا كَافَّةً فَلَوْلَا نَفَرَ مِنْ كُلِّ فِرْقَةٍ مِنْهُمْ طَائِفَةٌ لِيَتَفَقَّهُوا فِي الدِّينِ وَلِيُنْذِرُوا قَوْمَهُمْ إِذَا رَجَعُوا إِلَيْهِمْ لَعَلَّهُمْ يَحْذَرُونَ. Basically pointing out that not all Muslims should run off to battle, but rather there should be a contingent within the Muslims who would stay behind, so they study the deen, and when people come back from wherever they, whatever expedition or military endeavor they went out for, or it could be anything else, business, etc. When they come back, they have somebody there to teach them what the fundamentals of the religion are. So again, this verse alludes to the fact that there would be some people who are specialists in the religion, in the deen, and others who would be non-specialists, who would carry out, or who would serve the religion even in other ways other than learning Islam. And that is why I consider it to be quite pointless to try to prove the obligation of ijtihad upon the mujtahids and the obligation of taqlid upon the muqallideen, because these are logical obligations. And even those in history who have traditionally claimed, like Ibn Hazm and Ash-Shawkani and Siddiq Hasan Khan and the Zahiriyya, who have said that taqlid is haram, even they have obligated the layman to refer to a scholar and simply ask the scholar, is this ruling from the Quran and Sunnah? If the scholar says yes, then that is sufficient for them. So, I mean, even those scholars who on paper prohibit taqlid, even they suffice with this amount for the layman to have discharged his or her obligation in reference to istifta, or in reference to asking a scholar. Whereas obviously the overwhelming majority of scholars don't even place this obligation upon the layman, and they simply say to them that they simply have to refer to a scholar who is an authority and who is of sound character and upright. So that is taqlid basically. So here's a summary of the course that we've discussed over the past 20 or 21 lessons. So as I mentioned, this was the first time I've been delivering this course, and I didn't know how many lessons I would need, so I just took a judgment in the beginning that would be 20 lessons, and alhamdulillah, we covered most of the topics within the 20 lessons. I've gone back to some of the recordings, and already I'm looking at some things I've said, and upon reflection, I would have phrased some things better. So forgive me if I made any errors, or anyone who accesses that course afterwards on demand. But khair, that is human nature, and inshallah I'll put some effort later on if I ever get a chance to deliver an updated version of this course to address those issues. But whatever I have done, I've tried to rectify those errors in subsequent lessons, as I'm sure you're all aware. We've covered a lot of ground, but what I would say that the overriding theme has been is the human element in the shaping of the discourse surrounding Ijtihad and Taqlid and other issues as well. Because as we'll discuss soon, Ijtihad and Taqlid, just like the majority of other aspects of usul and the sciences of Islam themselves, they weren't spun off until later on within dedicated scholarly texts. So in the beginning, obviously, you had the Quran and Sunnah, and in written format, you only had the Quran. And the Muslims or the elite were apprehensive about recording even the Hadith alongside the Quran, but later on that permissibility was given as per the instruction of Umar ibn Abdul Aziz to Shihabuddin al-Zuhri. And then the Hadith was compiled, and later on fiqh was compiled. Obviously, Imam Ahmad didn't write a book on fiqh, rather his masail were compiled by his students. Imam Abu Hanifa doesn't have a book on fiqh, but rather his student compiled his fatawa. Imam Malik has his Muwatta, obviously, and in terms of the Mudawwana, that was compiled by his students and students. And obviously, Shafi'i has his Al-Umm. But fiqh authorship only took on in earnest 2 or 3 centuries later, in the form of Tadween being completed. So fiqh was spun off. Then eventually you had certain elements within fiqh that were spun off that were considered to be important enough to be spun off. So you had qada, you have books on qada, and you have books on the awqaf, the Islamic endowments, because Islamic endowments played a huge role in the economic life of the Islamic State. And things proceeded as thus. In terms of usul al-fiqh, obviously Imam al-Shafi'i has his al-Risalah, but the manner in which usul al-fiqh was later developed, that only came about in earnest from the late 3rd and early and 4th century onwards. And then fast forward a few hundred years, the topics of taqlid and ijtihad weren't discussed in spun off standalone texts, but rather they were contained within the usul texts. And also if you look at something like maqasid, so maqasid was always there contained within the body of the Quran and Sunnah, but it was only started to be discussed as a standalone subject in usul texts later on. So you have maqasid being discussed by scholars like Ibn al-Qayyim in his I'lam al-Muwaqqi'in, and you had Ash-Shatibi in his Al-Muwafaqat. I'm sure scholars before, like Ghazali and Ibn Taymiyyah, they have discussions on maqasid as well. The first standalone text on the maqasid is Tahir ibn Ashur, of the Tunisian scholar of recent, the author of At-Tahrir wa Tanwir. So today we all know the importance of maqasid in the context of ijtihad. But consider the fact that maqasid was only written as a standalone text. On the topic of maqasid, the first author to write on it was Tahir ibn Ashur. That's like 1,200 years, 1,300 years since the advent of Islam. And even when Tahir ibn Ashur wrote it, he didn't write it as a matter of ta'sil. He wasn't establishing the principles, but rather it was a contemplative effort on his part. Ta'ammuliyun la ta'siliyun. So he was merely trying to initiate the discussions with regards to maqasid. So these things take time to develop. These things take time to evolve. So in terms of taqlid, the first standalone text is by As-Samhudi of the Shafi'is, who died in 911 after Hijrah. One of the first texts encouraging scholars to do ijtihad was by Abu Shama al-Maqdisi in his al-Mu'ammal, or his Mukhtasar al-Mu'ammal fi al-Radd ila al-Amr al-Awwal, and he was a 7th century scholar, I believe. So I mean, it was discussed before, but contained within the larger body of usul. So I mean, these are importantly, greatly important, or very important discussions, but yet they were only spun off as standalone subjects later on. And that is the nature of how sciences evolve. So Islamic sciences are no different from other sciences, and obviously the human element in these is there for everyone to see. You'll have each author with their own flavor in writing, and you can see the author's personalities coming through. Likewise, in Adab al-Khilaf, the first authorship was by a scholar al-Batalyusi, and then after him, Ibn Taymiyyah wrote his famous Raf' al-Malam an al-A'immat al-A'lam, which is the standard of the topic of Adab al-Khilaf. And likewise, we have books in Siyasa like Al-Ahkam al-Sultaniya by Mawardi, Ahkam al-Sultaniya by Abu Ya'la. Those are 5th century scholars. So these things take time to develop. We also discussed the need for ijtihad within the ummah, and that delivers a degree of competence. And wherever there have been calls for imposing taqlid even upon scholars, or claims that the doors of ijtihad have been shut, then that has had a detrimental impact on the intellectual state of the ummah. And you saw what Mustafa Zarqa said in his Al-Ijtihad wa في ودوره في حل المشكلات, an article he wrote in which he said that towards the Ottoman Empire, that calls for ijtihad being banned and imposing taqlid was so strong that some scholars were that any claim of ijtihad was threatened with death, capital punishment. So when the Khilafah fell and scholars weren't engaged in that level of critical thinking that is required for mujtahids, the level of expertise wasn't there to guide the ummah through that greatest time of crisis. And only decades later did the Majami' Fiqhiyya being started established. And the Majami' Fiqhiyya obviously do ijtihad, and they try to solve the new issues that are arising within the post-industrial revolution era, the mass communication era, the mass technology era. And obviously issues that need to be discussed have grown exponentially over the past few decades, and I'm sure it will continue as such within our lifetimes. So scholars need to be ready for that. They can't simply rest upon classical texts and not develop expertise that are relevant to guide the Muslims in a manner that would be suitable for them to live both faithful to their to Islam, but also in a way that is compatible to the modern era. We're not in the process of or Islam isn't in the process of creating monks or Luddites or people who are basically anti-technology, which the Sharia has nothing to say. He hasn't said anything in terms of its prohibition, at least. That is been left for the man. That's been left for man. Allah has left those issues for man. And even in the hadith which we discussed earlier on in the course with regards to the issue of date tree pollination, in which the Prophet ﷺ gave the Sahaba some a comment that I don't think this will work, and he walked off, and later on it didn't grow fruits. So the Sahaba told the Prophet ﷺ, the Prophet ﷺ said, this hadith in Sahih Muslim. So he said that to the effect that these matters pertaining to the world you know better than I do. I deal with wahi, but when it comes to issues pertaining to the world, then you know better than I do. So the Prophet ﷺ acknowledges that expertise, at least when it comes to the issues pertaining to the world, other people might have it better than he himself, sallallahu alaihi wasallam. So there is a recognition within the highest level of the Sharia, which is the Sunnah, that different people have different expertise in different fields of life. And especially with the rise of Muslims living in non-Muslim nations, and the fiqh al-aqalliyat, or the fiqh of Muslim minorities, which unfortunately some people to this day deny as a standalone subset within fiqh. It does exist, and it still needs to be developed further, as we'll discuss later on, perhaps in the Q&A. That the fiqh al-aqalliyat, can we still live by the old models that are discussed by Muslim authors who lived in ancient Muslim lands, for us Muslims living as minorities? Do issues, for example, pertaining to the distinction between Darul Harb and Darul Islam, and no third abode in between, no third abode being in existence, is that still applicable for today? Even Ibn Taymiyyah has a discussion on that he didn't believe that there were two abodes, Darul Islam and Darul Harb left, but rather he devised a hybrid form of Dar, in which the Muslims were able to practice one their religion, but nonetheless they were living under a non-Muslim ruler, the Mongols. So these are discussions, even though ancient Muslim scholars discuss, but they're not set in stone, in the sense that they were speaking from their context. If the context changes, especially in the modern world, the context has completely changed, then scholars need that competence with regards to Ijtihad to be able to devise rulings that are suitable for Muslims to live in a manner that is compatible both with their faith and also in harmony with the modern world. Because the alternative, as we discussed last week, is that we maintain the old rules and make Muslims en masse feel guilty about their practices because they're not conforming with those old rules. And that is why we discuss, as we'll discuss in the next slide, some scholars like Rashid Ahmed Gangohi and Tanwi and Badruddin al-Halabi of Syria and others, they've said that we need to devise a fiqh model that is updated for today's purposes. I mean, these scholars are talking about 100 years ago, when they were in colonialism. Obviously Syria was colonized, and likewise the subcontinent was colonized. So they were discussing from that context. Imagine for today, when the situation has changed even more. So they said that we need to devise a fiqh model in which we have pre-prepared fatwa which we can issue to the people, that would create ease for them rather than guilt trip them into the default rulings of the madhab, or the mashhur of the madhab, or the muftabi of the madhab. So they said no, that is not a sustainable model. Fiqh in its purest sense is not only about encompassing furu', but rather fiqh in its purest sense means ijtihad, and the ability to analyze. Not only analyze the Quran and Sunnah, but also analyze the ground reality and the real life situations of the Muslims. And we touched upon the fact, this question was issued a number of times, and it is a valid question. So how do we reconcile between some fatwa issued by ancient scholars? They seem to be completely impractical, like the Hanafis, who issued the fatwa with regards to the woman and her lost husband. How long does she wait before she can get an annulment in marriage so she can remarry? So the Hanafis either said that she can't, or it's 120 years, or 110 years, or 190 years. 90 years. So, which is completely impractical. So how is it possible that they could devise such a ruling? So we identified that there's two types of ijtihad. One type of ijtihad is a theoretical ijtihad, what the Quran and Sunnah say, and that's it. And one type of ijtihad is the ijtihad tatbiqi, or what you say, or what the non-Hanafi say, tahqiqul manat, or ijtihad maqasidi, ijtihad maslahi. There's a variety of terms for this, in which you apply a ruling in a real life situation for X, Y, and Z person. So even though you might have a rajih based in the Quran and Sunnah, but that might not be practical. So you simply give a ruling according to another madhab, or you refer the mustafti to the scholars of another madhab. We discussed recognizing the dynamic nature of fiqh, and that fiqh is ever evolving, it's never static. We also discuss the cause of the rise within certain madahib, and also the fall of other madahib and them going extinct. And that is not because of any particular divine intervention, but rather politics played a huge role. The judiciary played a huge role as well, as we discussed from Ibn Badran, and also from Qadi Iyad in his Tartib al-Madarik, and Al-Wansharisi in his Al-Mi'yar al-Mu'rib, how the Maliki madhab spread to the Maghrib and Andalusia, before which Al-Awza'i's madhab was dominant and present. And likewise in Egypt, before Shafi'i came, the students of Malik were already there. So when Shafi'i showed up, that caused a bit of tension between Shafi'i and certain students of Imam Malik, namely Ashhab, who, by the way, had some funny things to say about Shafi'i when he showed up in Egypt, and also he supplicated against Shafi'i in his sujood that if Shafi'i stays around for any longer, then our madhab will die. So that's what Ashhab said. And we also discussed before him that before he went to Egypt, Shafi'i was considered to be from the ashab of Imam Malik within Iraq. So when he started to diverge slightly from the madhab of Imam Malik, because he was a student of Imam Malik, his colleagues said that if you're going to continue down this path, you'll be forgotten. You'll be like excluded from the Madani madhab, which was at the time which was the proto-Maliki madhab. It was known as the Madani madhab. It was referred to as the Madani school, Madhabu Ahl al-Madina. We discussed the Ijtihad form factor. So Ijtihad is not only looking into the Quran and Sunnah directly, but also Ijtihad takes a variety of forms. So you have Tarjih, which is looking at the aqwal of the scholars before the Mujtahid looking at the aqwal of the Mujtahids before him or her, and then assessing the evidences via the means of precedent. So, and we identified that some modern day methodologies in fiqh that emphasize going directly to the Quran and Sunnah, they discount the basic fact that precedent is important. It's like Imam Ahmad said, إِيَّاكَ أَن تَتَكَلَّمَ فِي مَسْأَلَةٍ لَيْسَ لَكَ فِيهَا إِمَامٌ. Beware of speaking in any issue in which you don't have an imam, you don't have precedent. So you need to identify precedent, and then you can analyze the evidences. Because disregarding precedent brings about the possibility of falling foul with ijma', because ijma' is just a whole body of aqwal or statements from the scholars who happen to agree on one issue. So if you're going to completely disregard precedent, what's that going to lead to? That's going to lead to extracting a rule from the Quran and Sunnah, but there's already ijma' against it, and the alternative rule is the place where the ijma' occurred. So another form of ijtihad is intisar, which is defending your imam or your madhab in the form of new evidences. And there's other forms of ijtihad as well, like takhrij, al-furu', tafri', and he has other terms as well. Ijtihad is synonymous with tarjih, ikhtiyar, etc., etc. And those are all ijtihad form factors, even though later on many would identify these as a format of taqlid. But in reality, if you're looking into evidences and arguing on behalf of your position or on behalf of your imam, then that is a form of ijtihad. We briefly touched upon the fact that the issues pertaining to Ijtihad and Taqlid are madhab agnostic. So if you have a position in Taqlid, then that would be applicable to all the madhahib. Because as we discussed, discussions on Ijtihad and Taqlid, they're rational, and they're logical. They're not based in the details of those are not based within the Quran and Sunnah. The details of those are based on aql. Okay, once we have the obligation of ijtihad upon mujtahids and the obligation of taqlid upon muqallids, the details of that, as to do you have to follow the most knowledgeable scholar in the context of taqlid, do you have to stick to a madhab or not, can you exit the madhab in single issues having adopted a madhab. So these are individual issues, and the arguments on both sides is just simply logic. I mean, one might draw support or infer support from Quran and Sunnah texts, but they're largely indicative and they're not definitive. Also, the details of ijtihad. So, is amalu ahli al-Madina hujjah or not? So Imam Malik would argue for it, the other madhahib would not. Is the ijma' of the khulafa arba'a hujjah or not? The majority say no, it's not hujjah, because other sahaba in terms of fiqh, they would be, their level is, in terms of fiqh, they're equally as competent in terms of their fiqh, faqaha and ijtihad as the khulafa arba'a were. Are the aqwal of the major tabi'een, are they hujjah or not? So these are issues discussed in ijtihad, the details of which are differed over. And again, support is driven for all of these positions from the Quran and Sunnah, but they are largely indicative and not definitive. So at the end of the day, these discussions, these details which are differed over, they're largely rational discussions. Okay? Not only what's rational, but also what's most suitable. And that can differ from context to context, from geography to geography, from era to era. The split of scholars geographically in issues pertaining to the adherence to a madhab. So we've identified certain trends. So for example, in a place like Egypt, barely anybody in history over there ever said that you have to adhere to a madhab, for a muqallid to adhere to a madhab. And the Mamluk had a role to play in that, in the sense that they established courts from all four madhahib. Also in places like Iraq and Syria, traditionally, they've always been against the notion of adhering to a madhab, for muqallids at least. Whereas in places like traditional or classical Central Asia and Maliki, Andalusia, and some elements of Yemeni, Shafi'i Yemen, they advocated a form of adherence to a madhab, to a particular school. We also discussed the definition of hawa, and when does one fall out from go out from the domain of following a madhab or following a rukhsa and starts following hawa. We discussed that, and we discussed the idea that is largely subjective based on whatever your opinion in taqlid is. So if you're of the view that you have to stick to a madhab, then not sticking to a madhab would be hawa. Okay? If you're of the view that you have to stick to the most knowledgeable scholar, then not following the most knowledgeable scholar would be hawa. If you're of the view that you have to stick within the four madhabs, but you can't go outside of it, then going outside of the four madhab would be hawa. So it's all the establishing hawa is always relative to whatever position you hold on taqlid. The mujtahid levels are a legal fiction, giving rise to an improper conceptualization of mujtahids and ijtihad. So these levels were created by Ibn Kamal Pasha of the Ottomans. In his he has a small book, Tabaqat al-Mujtahidin. There's manuscripts of that floating around, and some have said it's part of another book he wrote. So his categorization of mujtahid levels is really problematic, and the simple reason why it's problematic, as we identified, is because mujtahids engage in different types of ijtihad. So the top level of mujtahids, so for the four imams, for example, they weren't doing ijtihad directly from the Quran and Sunnah all the time. Imam Abu Hanifa and Imam Malik were largely following the legal trends that were already pre-existing in Kufa and Medina, respectively. Likewise, Shafi'i, before he showed up in Iraq and before he showed up in Medina, he was following whatever the Meccans were saying. His teacher, Muslim bin Khalid al-Zanji, and his teacher, Ibn Jurayj, taken from the fiqh of Ibn Abbas and Ata and Ibn Uyayna and all these scholars. It's only when as I mentioned here, regional fiqh before Shafi'i came. So before Shafi'i went to Medina, so he combined the knowledge of Medina and Makkah with Medina. Then he went to Iraq and he combined the knowledge of Hijaz with Iraq. And at the end, he was in Egypt. He also had a brief stint in Yemen. So in the end, he was Egypt. He was in Egypt. So he had combined the various regional fiqh centers and their knowledge into himself. So he was really the first scholar who transcended regional fiqh and became a mujtahid scholar independent of any particular region. Whereas Malik is very closely associated with Medina, and Abu Hanifa obviously is very strongly associated with the Kufa. I mean, they did have interactions. Imam Abu Hanifa went to Hajj, and Imam Malik had interactions with the various scholars coming from across the state. But they weren't as diverse in their experiences as Imam al-Shafi'i was, and this is obviously one of the virtues of the Shafi'i madhab. I mean, all of the madhab have their own individual virtues, but this is one of the Shafi'i's madhab's virtue. In addition to the fact that Shafi'i obviously had his madhab qadim and madhab jadid, so he lived long enough to revise his madhab qadim. And his madhab qadim was from Iraq. His madhab jadid, his new madhab, is basically the opinions he adopted in Egypt, having studied there with the students of Layth ibn Sa'd, or having interacted with the students of Layth ibn Sa'd. Layth ibn Sa'd was the mujtahid, a contemporary of Imam Malik, and he died before Shafi'i arrived on the scene there. The fiqh outside the four schools and outside the mainstream positions of any one school is still relevant. So what does that mean? So we know for a fact that, especially in the modern context, where we have models of Islamic finance and certain Islamic economic models, and also the fiqh of other aspects of dietary law and other areas, you see scholars taken from outside the four madhabs, out of ijtihad, obviously. And that ijtihad might not even be rooted in the Quran and Sunnah, but rather, if it's established within the broader framework of the Quran and Sunnah, so long as those opinions are valid, then those opinions have been adopted as a rukhsa for the Muslims. Like we discussed earlier, that Muslim scholars, there's an increasing awareness on the part of Muslim scholars that rukhas need to be provided for Muslims in issues that affect them en masse or worldwide. And also from outside the mainstream position within any one madhab. So if you're a Hanafi or a Maliki, and if the maslaha dictates that you don't take the mainstream position of your respective madhab, but rather a position from outside that is not the mainstream, then that would be permissible as well. I mean, the majority of scholars allow a muqallid to take from outside his or her madhab anyway. So, I mean, there's great flexibility as we establish in terms of how the obligation of taqlid should be discharged by the muqallid. We also discussed the problem of attribution of positions and evidences to the earliest imam. So, yeah, this is a great problem. So in later texts, you'll find evidences supporting the position of your imam or the madhab's imam, when in fact the imam never employed that evidence. And had he been aware that this evidence was being used to defend his position, he would have disapproved of it. Why? Because the hadith is either weak or is being misapplied, or the qiyas that has been used has been misapplied, or the claim of ijma that has been made, that claim of ijma is incorrect. And this is something Ibn Taymiyyah identifies, this is something Shah Waliullah identifies. So when a student of knowledge is advancing in his or her fiqh studies, they should always be discerning of the fact that some of these adillah or evidences that are discussed in the later texts, they're not necessarily the evidences used by the imams themselves. And this really becomes a problem when a lot of weak ahadith are being inserted into the madhab to defend the imam's position. And this is a phenomenon that was condemned by scholars like Ibn al-Qayyim and Ibn Abd al-Salam and Ibn Rajab and many others, that weak ahadith are appropriated to defend the imam. And also positions themselves. So many of the fatwa you'll see in later fiqh texts, They're not from the Imams. They're rather derived from the verdicts of the Imams. So takhrij. So is it a position of the Imam directly, or is it a takhrij based on a position of an Imam? So again, that is an issue which has got really muddled up in some madhab, especially the Hanafi madhab, because and also the Maliki madhab to an extent, and also the Hanbali madhab to an extent. We also discussed the importance of distinguishing between the terms taqlid, tamadhub, iltizam, talfiq, ijtihad, and that many scholars later on would use these terms interchangeably. So specifically in relation to the terms taqlid and tamadhub and iltizam basically means adhering to a madhab. So proving the obligation of taqlid does not prove the obligation of tamadhub, adopting a madhab, and proving the obligation of tamadhub does not necessarily prove the obligation of iltizam, meaning you have to stick to the madhab in all its rulings. As we discussed as a classic case study, Ibn Hajar al-Haytami was of the view that adopting a madhab is wajib. But he was also strongly against iltizam, meaning a person adopts a madhab of a Shafi'i, but he or she can still go outside of the madhab in individual issues. So proving the obligation of one does not result in proving the obligation of the other. Proving the obligation of taqlid does not prove the obligation of refraining from talfiq. Yeah. Proving the obligation of ijtihad upon the mujtahid does not preclude the fact that the mujtahid might do taqlid in some issues, and we've discussed many examples of this, like the story of Abu Yusuf in Jum'ah, and the scholars differing over how to interpret that story when his well water was found to be impure, and also the story of Abu Tayyib al-Tabari, the Shafi'i scholar of the 5th century, who adopted the Hanbali position on the spot before starting his prayer due to some event that befell him. Bird droppings, which are impure in the Shafi'i madhab, but then he said, Ana Hanbaliyun, I am a Hanbali in this matter. In their madhab, the bird droppings are not impure. And also realize the fact that some scholars might use these terms interchangeably. So some scholars might refer to iltizam as tamadhub, or some scholars might refer to tamadhub as taqlid. You must do taqlid, meaning what they're trying to say is you must adopt a madhab. You must do taqlid, what they mean is iltizam. You must adhere to all the rulings within the madhab. So a student needs to be discerning of that fact. We also discuss issues surrounding tatabbu' rukhas and talfiq, and they're not as clear as one might initially glean from the texts. Because discussions in tatabbu' rukhas and talfiq, they weren't spun off until really later on within classical legal usuli discussions. So you have an absence of discussion on talfiq, for example, for 500 or 600 years, roughly. And then you have some scholars starting to speak about the prohibition of talfiq. You shouldn't mix up the madahib. That leads to a scenario which is not permissible in either madhab. Then after that, you'll see the phenomenon of scholars refuting that. So they allowed talfiq. So that they typically started in 800, 900 Hijri after that. So some argued that they argued that the scholars who prohibit talfiq, they precede the scholars who allow talfiq by 200 or 300 years. So the answer to that which was given is that before 500 Hijri, talfiq wasn't a matter of concern at all. So the default in that situation would be that it was considered permissible. Only when scholars started to prohibit it, and those who allowed it caught on 200 years or 300 years later, as I said earlier on, these things take time to be discussed and refined in the texts. Then those scholars started to speak out that no, it's allowed and there's no logical text that prohibits it. But nonetheless, talfiq, we discussed the levels of severity and the difference of opinion. In the middle levels, the less severe levels are the majority of scholars would allow, and the most severest levels of talfiq, scholars would not allow those formats of talfiq. There's around 7 or 8 levels which we discussed. We also discussed the domains of qada, ifta, and amal khas, and they all have different rulings applicable to them in terms of the obligation of adhering to a madhab or not. So must the qadi adhere to a madhab or not, or is that dependent on what the hakim tells him? Must the mufti adhere to a madhab when issuing rulings or not? So we discussed the variety of approaches in that regard across the madhahib. In amal khas, which is personal practice, must you adhere to a madhab or not? And that differs from ifta. Proving the obligation of adhering to a madhab in the context of ifta does not prove the obligation of adhering to a madhab in the context of amal khas, as we established from Ibn Hajar al-Haytami. Again, his name comes up quite often because he's quite a he's a scholar who's discussed these matters at length. So he said, in the context of ifta, a Shafi'i mufti cannot exit the Shafi'i madhab at all, and in fact he was of the position that a Shafi'i mufti cannot even take into consideration maslaha, which was an extreme position on his part. Yet at the same time he also says that a muqallid can take from whichever madhab he wants or she wants after having adopted the madhab, he said. So it's interesting the difference he makes between ifta and amal khas. But also in the context of pedagogy, which is ta'aleem, must you adhere to a madhab or not? So what is understood from the scholars is that yes, you have to adhere to a madhab, otherwise you can't adopt every single during the process of your study. You can't take from all the madhahib, otherwise you'll just become confused. That's the nature of studying. It's like someone studying English law and French law and Spanish law at the same time. So it wouldn't make sense. So one would have to stick to a madhab, and then in the process of study, and then branch out to other madhahib. Also, something which we didn't discuss, unfortunately, but it is as pertinent to the discussions on Ijtihad and Taqlid, is the issue of al-iqtida fi salati bil mukhalif, reading behind an imam who is not of your madhab. Okay. Also, we touched upon this slightly, the issue of awqaf. So during the Khilafah period, for 1,000 or for 1,200 years, you had the awqaf system. And during the Mamluk period, what happened was that awqaf started being established in the name of the people of a particular madhab. Okay, so this is a Maliki waqt, this is a Maliki madrasa. Only the Malikis are allowed to teach there, or only Malikis are allowed to study there. And this gave rise to the phenomenon of scholars changing madhab just for the sake of jobs. And we discussed this theme again and again and again. People switching their madhabs for financial purposes. I mean, our Islamic history, legal history at least, isn't as rosy as some portray it to be. I mean, people were human at the end of the day, and subhanallah, things happened which we, looking back in our tariq and looking back in our history, we wouldn't be proud of those aspects being part of our Muslim history. The Hanbalis fighting with the Shafis and not allowing them to read Bismillah allowed in Salah and Qunut in Fajr, and when the Shafis got the upper hand, they didn't allow the Hanabila to act in a way that was compatible with their madhab. So you had all these skirmishes happening across Islamic history. In the context of siyasa, must a hakim or a qadi, must a hakim adhere to a madhab or not, or can he adopt whichever opinion he wants based on maslaha? So those are discussions we talked about from Al-Mawardi's book, Al-Ahkam al-Sultaniya, and also I believe Qadi Abu Ya'la's book, Al-Ahkam al-Sultaniya. We discussed accommodation in ihala or tafweed. So accommodation basically means accommodating an alternative opinion in the process of ifta or in the process of qada, and ihala simply means referring a mustafti or a muqallid or a layman to another mufti, because they would be able to get an easier opinion which you wouldn't be able to dispense, because you as a mufti or as a mujtahid aren't able to pass verdict according to that view, because you're simply not of that view. And we also discussed istinbat versus tatbiq, which is theoretical ijtihad versus dispensing a fatwa in a real life situation, and the difference between the two. You might have a preferred position in theory, but you might still not pass it in practice because it might simply be impractical. So at the end of this course, what are some pieces of advice I can humbly submit to those who have participated in it? As you can glean from these 20 odd lessons, the issues of Ijtihad and Taqlid, this subject is a really rich subject. It's not only a matter of do you have to follow madhab or not, or are the gates of Ijtihad closed or not. The only reason people one might see these discussions to be limited, when in fact they're not, we have a really rich heritage in this regard across the madhahib. is that discussions on Ijtihad and Taqlid weren't really spun off, as I mentioned earlier on, into individual standalone texts until really later on. Okay? It's only from the 10th century onwards that you have standalone texts on Ijtihad and Taqlid, and then when they started, then boy, they did come out flowing. So you have dozens of texts that have been written on Taqlid, starting from as-Samhudi, and also on Ijtihad. But there is also another problem, which is that the matters of Ijtihad and Taqlid isn't really discussed in some usul texts. And if you look at the curriculum in Hanafi Madaris in particular, the usul texts that are written on the Central Asian format, or the Tariqatul Fuqaha format, they don't unfortunately have discussions on Ijtihad and Taqlid at the end of, and most of them don't have discussions on Ijtihad and Taqlid at the end of their texts. So students are left in the dark, and they're left to fill in the gaps by themselves. So when they then study issues pertaining to Rasmul Mufti, or the code of Ifta, and you'll find Ibn Abidin in those and others in those books, also from other madhab, they say that a mufti must stick to the mashhur, or the mufta bihi, or the mainstream position, or the mu'tamad. Students are then left to fill in the blanks, that because the mufti must stick to the mashhur, and muqallid must stick to the mashhur as well. And that is not really how taqlid works, because the obligation of a mufti is completely separate from the obligation of how a muqallid should discharge his or her obligation of taqlid. What is an obligation on a mufti is not necessarily an obligation on a mujtahid. If a scholar is of an opinion, like Ibn Hajar was, that a mufti must stick to a madhab in the process of ifta, that doesn't translate in his view to a muqallid sticking to a madhab. So my advice is, if you want to go further into this topic, then read the books on taqlid and ijtihad, and also the books of usul fiqh, also the fatawa, and then you'll find pathways opening up to you. Then you'll find individual issues of ijtihad and taqlid being discussed in the books of fiqh themselves, as we identified in the course, the issue of Hanafi asking a Hanbali in the context of khul' to avoid divorce, or Hanafi asking a Hanbali in the context of fasting and hijama, and the fact that it breaks fasting in the Hanbali madhab. Then Hanafi thought that his madhab his fast broke. Then what should he or she do? So you'll see individual issues scattered across the body of fiqh being discussed that are essentially a discussion on Ijtihad and Taqlid. They can be transported to any other fiqh issue. They're not specific to the issues of al-iqtida fi salat bil-mukhalif, or hal as-sa'im tufattiruhu al-hijama, or the issue of as I just mentioned earlier on. So it is important to study the historical context when studying Ijtihad and Taqlid, because a lot of ahkam that we find from earlier scholars, they're based on context and the situations they were presented, they were in. So a lot of rulings pertaining to the prohibition of taqlid was to do with politics, especially towards the end of the Ottoman Empire. There was a lot of theological backlash against the Ash'aris in Central Asia. Obviously, there were Maturidis there, so you'll find verdicts that seem to be against the Shafi'is, but in reality they're against the Ash'aris, because Shafi'is were predominantly Ash'aris. So the verdicts that say that a Hanafi can't marry a Shafi'i, that's based in theology because of some certain Ash'ari beliefs. Specifically the issue of al-istithna fil iman. So history and context are important. Books, I mean, yeah, so Al-Iqdul Farid is the first book that I'm aware of that has been written on Taqlid, but also there are many other books written, and I happen to, there's a few online, there's a few still in manuscript format, and there's a few you can find in bookshops, so I have a few. So you have Shurum Bulali and his book Al-Iqdul Farid fi Ahkam Taqlid. It's been published as a standalone book, and it's also been published as part of his Majmu' Rasail. You also have this book Fathul Majid by Ibn Jammal. Fath al-Majid bi Ahkam al-Taqlid. He was slightly after Al-Iqd al-Farid. This is Al-Iqd al-Farid, the original book. Al-Iqd al-Farid fi Ahkam al-Taqlid by Samhudi, the Shafi'i scholar. خلاصة التحقيق في بيان حكم التقليد والتلفيق by Sheikh Abdul Ghani al-Nabulsi. So this book refutes talfiq, so it disagrees with talfiq, meaning he allows a muqallid to not adhere to a madhab, but he also stipulates that whilst not adhering to a madhab, you must also not perpetrate talfiq. And also, obviously, the Hanafis differ in this regard. Some allow talfiq, some don't allow talfiq. The book that allows talfiq is the book written by Ibn Farrukh, and that's also been published by the name of, also I believe Al-Iqd al-Farid. These names can become confused. Ad-Durr al-Farid, Ad-Durr al-Farid is by Al-Hamami, by the way, and Dr. Salah Abul Hajj uploaded his books on archive.org, and one of the books is his edit on Ad-Durr al-Farid by Hamawi, the Hanafi scholar. And obviously you have Shah Waliullah's book Al-Insaf and Iqd al-Jid. So they're interesting because he's the first real Indian scholar to discuss these issues. And then you have contemporary books. So there's been many books written in the issues of taqlid and ijtihad, but this is one which is a 3-volume book by Sheikh Khalid bin Musaid al-Ruwaiti. He's a teacher in Kulliyat al-Sharia in Imam Muhammad bin Saud in Riyadh. His book is Tamadhub. I believe this was his PhD thesis. I've read the book a few years ago. It's okay, but I think 3 volumes doesn't do justice to the rich heritage we have in taqlid and ijtihad. I mean, if I were to make a guess based on my readings, you'd at least need around 15 or 20 volumes of that size to fully encompass all the discussions surrounding Ijtihad and Taqlid, theoretically, historically, contextualizing it with contextualizing the edicts of past scholars and how their environments or milieus influence them, the rise of the madhahib, etc., etc. So, I mean, it's a really rich subject that needs more attention academically. And it's also, importantly, a topic that needs to be moved away from polemics. Unfortunately, for the past 50 years, maybe more, issues of taqlid and ijtihad have been subject to polemics at a scale that, subhanallah, no other subject has been subjected to. Not even issues of aqidah. Not even issues like asma and sifat. Not even issues like, the manhaj wars. The topics of Ijtihad and Taqlid, for some reason, people get emotional, and I think that is a remnant of the later part of the Ottoman Empire, where Ijtihad was completely banned. And I mean, there's other factors as to why this became consumed by polemics and didn't remain an academic issue like other aspects in usul. You won't find people arguing over am and khas and whether am is qat'i or not. And that's an usul discussion no less than the discussions on Ijtihad and Taqlid. You won't find people arguing over whether, for example, Isharatun Nas is qat'i or not, indicative texts. You won't find discussions on whether Qawl al-Sahabi is a hujjah or not in a polemical way. No, you wouldn't. It's just Ijtihad and Taqlid that have been subjected to this regime of polemics. So if anyone's really interested in this issue, they need to move out from the polemical arena and really start investigating the issues for themselves, away from argumentation, and start reading what the scholars have actually written in this regard. And ideally, you want to read somebody before, from a few hundred years ago. So start from the beginning. Start from the usul texts. Start from 1,000 years ago. So start reading about what they mention about Ijtihad and Taqlid. Start reading from Al-Fusul fil Usul by start reading what Al-Jassas said. Yeah. Start reading what Abu Ali al-Saymari said of the Hanafis. Start reading what Al-Qarafi said. Start reading what for the Shafi, what As-Subki and Al-Haytami and all these scholars said. Abu Shama al-Maqdisi. Yeah, for the Hanabila, I mean, their literature is vast and rich in this regard. Start reading what Ibn Taymiyyah said, Ibn Muflih said, Ibn Hamdan, Abu al-Khattab. I mean, the list goes on. So our heritage is very rich in this regard. And if you don't want to pursue further studies in Ijtihad and Taqlid, then the key lesson here is that understand that there's great flexibility. I mean, it's really hard to find any Muslim who doesn't conform to some methodology, some valid methodology in Taqlid. Even though if they might not even want to call it Taqlid, that they refuse to accept the term Taqlid. But in your definition, they're doing Taqlid. Okay, so leave them. I mean, there's no point arguing. The only case where there is possibility for some harshness or strictness to be administered is when people start refuting other people over valid positions they hold or over valid methodologies they hold. So if someone believes that their entire model of taqlid is incorrect, or their entire model of following scholars is incorrect, or their model of following hadith, then more likely than not, they themselves are wrong for condemning, because the majority of positions in taqlid and ijtihad, they're like subject to difference of opinion, and there's great flexibility, and we shouldn't be really harsh with one another over these issues. And at the end of the day, if someone through the ijtihad and taqlid arrives at a completely incorrect position, which is not even a matter of ijtihad and taqlid, but rather a clear-cut nas, which should be a matter of ittiba', then scholars are there to condemn them for that. Scholars are there to condemn them for that. So that is the end of the course, and obviously starting from this Saturday we'll be starting the introductory course on Ijtihad and Taqlid. So this will be covering the main aspects we discussed in the previous course for those who aren't able to study or speak Arabic or do a fair bit of reading away from class. So visit the website to register if you're interested, or if you know someone who's interested in topics of Ijtihad and Taqlid, then feel free to refer them to this. I will leave it at that, and we'll take some questions if there are any in the chat. Okay, khair. Somebody asked, what is the role of Ijtihad and Taqlid in a post-madhab society and attendance structures, given that madhab-based judicial system has pretty much collapsed? Yeah, so it's a fact that madhab adherence was not driven by individual Muslims adhering to a madhab, but rather qadis adhering to a madhab, and the state imposing one madhab upon qadis. Like in Andalusia, all the qadis that were appointed were Malikis, and the Awza'i madhab was driven out. Abu Yusuf al-Qadi, Qadi al-Qudah, was obviously appointing only Qudat who were from his own circles in Kufa, and eventually in Baghdad. So that they would typically be Hanafis, and you had obviously, and this happened in many places. So the dominance of the madhab was mainly dependent on scholars of the madhab dominating the positions of qada, and that is why the Hanbali madhab never gained dominance. They did survive because of their sheer willpower, in not only in their love for the Imam Ahmad, but also the nature of the madhab itself, which developed as a strong madhab that adhered to the personality of Imam Ahmad, let's say, and that sometimes went into extremes. So discussions on Ijtihad and Taqlid, are they applicable today? Are those ancient discussions in Ijtihad and Taqlid applicable today, where there is no qada system or madhab-based qada system? So aspects of that are still applicable. So whereas other aspects are not. So it's not really how would you say, it's not really a discussion to have today whether a qadi should stick to a madhab or not, because that would simply be a hakim or a ruler telling the qadi that you must stick to a madhab for the purposes of uniformity in rulings. Whereas that is no longer applicable today. You don't have a ruler today who would tell a qadi, a ruler who has any purpose in making qadis adhere to a madhab. Number one. Number two, Muslim scholars need to train themselves up in maslahah. So they need to have a wider view of the Sharia and not simply confine themselves to their madhab. So the maslahah, the greater good, would necessarily entail that they keep an eye on edicts or verdicts, both classically and in the modern context from other madhahib. Going forward, how should Islamic institutes and seminaries develop their curriculum to build critical thinking skills with apt students, leading to ijtihad? So again, this is something what Mustafa Zarqa said in his Al-Ijtihad wa Dawruhu fi Hall al-Mushkilat. He proposed two suggestions. One is to establish the Majami' Fiqhiyya, which have been established across the Muslim world. There's multiple Majami'. There's a couple in Saudi. There's one in Egypt. There's one in India. There's one in Pakistan. There's multiple Majami' Fiqhiyya across the world, dotted across the world, and they're doing ijtihad as and when required. The other suggestion he gave is that the curricula need to be updated so that students at the end of it have a good grasp and have been trained up to do ijtihad. We're not saying that students are mujtahids at the end of the course. What we're saying is that they need to be trained up to do ijtihad. Rather than simply parroting precedent from the ancient madhab, they need to be trained to do ijtihad. They need to be trained to analyze issues objectively in a way that is faithful both to both the Quran and Sunnah, and also relevant to the modern context. So yes, curricula need to be overhauled, and the Islamic pedagogical system needs to be updated in that regard. I mean, if you have scholars like Badruddin al-Halabi in his Ta'lim wal-Irshad, and also Rashid Ahmed Gangohi and Ashraf Ali Thanwi of the subcontinent, obviously, they're saying that we need to devise a fiqh book or a group of fatwa that is relevant for people today, that would move away from the default of the madhab. If that is applicable to laymen, imagine for students and graduates. They need to be updated in their method of studies as well. We're not living in the Ottoman Empire anymore. We're not living in the Mamluk era. We're not living even 50 years ago from now. We're living in the now. And one of the greatest pitfalls in Islamic curricula is that our lack of ability to evolve with the times. So, khair. Since Sheikh Yusuf al-Ghafiz has developed new levels between Mujtahid and Muqallid, what would you endorse? I'm not sure what that means, but Sheikh Yusuf al-Ghafiz in his commentary on Raf'ul Malam Anil A'immat al-A'lam by Ibn Taymiyyah, he brings a level between Muqallid and Mujtahid. I think his levels are Nadir, Mutafaqih, and Faqih. Muqallid, Nadir, Muqallid, Nadir, Muqallid, Nadir, Mutafaqih and Faqih. He basically assigns different rulings to each level of person in terms of their stage, whatever stage they're at in terms of their fiqh studies. So it is a fact that the more you progress in your fiqh studies, the more you're able to analyze evidences, then the more capable of ijtihad you become. And at the end, once you've studied enough, then obviously a student of knowledge who has, especially if they've specialized in a particular issue, then they have the right to do ijtihad in that particular issue, if they have conducted reasonable research in their estimation. Again, the distinction needs to be made because a lot of people don't understand, is doing ijtihad does not mean you're a mujtahid. Doing ijtihad does not mean you're a mujtahid. Being a mujtahid is a title afforded by your peers, whereas doing ijtihad is the level for that, the bar for that is far lower. Being a mujtahid is a title which is afforded by your peers to you. So a scholar or a PhD Islamic studies student might do ijtihad in a particular issue he or she is doing a PhD in. That doesn't mean they're a mujtahid. The next question: after reading an immense amount of traditional works on the topic of Ijtihad and Taqlid, what is the ideal process and guideline you propose for the Mufti and the Mustafti, especially for those living in cosmopolitan societies with a mixture of followers from different schools? Yes, so this does have precedent. So what, if you look at ancient Egypt, not ancient Egypt, but the Muslim ancient Egypt, I'm not talking about the times of Fir'aun. The Muslim ancient Egypt is like in the Mamluk era, where there were a multitude of madhahib prevalent, and the Mamluks established courts from all four madhabs. And since then, Egypt has always been, even before that, it was always a multi-madhab society. So in that context, muftis need to realize that the society is multi-madhab. If a mustafti needs ease, don't pass fatwa yourself, because then you'd become a hujjah upon the mustafti. Just simply refer them to the other mufti. Okay? If you're not prepared to pass that verdict, which is in which is in contrast with your madhab or your position. In today's context, again, we need to update the rules on taqlid. Why? Because I wouldn't say the whole of the Muslim ummah now has access to the internet, but a large part of the ummah has access to the internet. So even if you're living in a monolithic society, that doesn't mean you don't have access to literature or material or fatwa from other madhahib. So in that context, what should be done is that there needs to be a mass education program of children of not an extremely young age, but children like going into high school, for example. They need to be made aware that these things exist, difference between scholars exists, and we Muslims have always lived with these differences. Okay, so these discussions shouldn't be kept within the elite or within the circle of students. And the sources of knowledge are not only going directly to the scholars and sitting at their feet to get a fatwa, but rather people nowadays ask fatwa online, fatwa from the online sphere. So that needs to be taken into account when devising rules for taqlid and istiftah. Another question we have here is this says, should the rules of taqlid always give consideration to the strength of evidence at some level? Think of a ruling you might be passionate about, whether it is women entering the masjid or the rulings of taqlid and ijtihad or whatever. If we presented the evidence for this ruling to someone, would we consider it acceptable for them to reply, I acknowledge you have strong arguments and that various scholars support your opinion, but I'm still going to follow the opinion of scholars X, Y, and Z. The scholars discussed this. They said that if a muqallid happens to come across a hadith and they feel so strongly in the hadith that they are unable to abandon it, that can happen to some Muslims due to their zeal in following the sunnah of the Prophet ﷺ. So long as there is precedent on the side of that hadith, they are allowed to follow the hadith. Okay? They are allowed to follow the hadith. This is in Al-Bahr al-Muhit by Zarkashi. It's also in Taqi Usmani's Usul Ifta, and it's also in other Ifta and Taqlid works. So so long as there's precedent backing that hadith, scholarly precedent, someone's acted upon it. So if no one's acted upon it, then they should be informed that if there's no one who has acted upon it, then there's no precedent. So there would be like an ijma that hadith has been abandoned. Okay. But when it comes to the issues pertaining to women entering the masjid, then that's a communal issue. So even if you have a view, that's not going to change anything. If a mosque is preventing women from entering or having a space there, that's a societal issue. That's not your personal opinion issue. Even if you have an opinion, that's not going to change the mosque administration's mind, is it? Should the rules of Taqlīd... Okay, we already read that. So, if we accept that following a specific madhab is not necessary, then if someone were to ask you for a ruling which you have not researched, what should be the basis of your fatwa? To present the opinion of your own madhab in this case is as optional as presenting the opinion of another madhab. Should this then obligate research? Again, this is an extreme hypothetical situation. A mufti, a person who is trained to do iftar, would typically or should have access to source whatever edict they're going to issue to the mustafti. And if they're unable to do that, they should refer them to another scholar. And if they're unable to do that because there is no other scholar available, then in that situation, تَعَيَّنَتْ عَلَيْكَ الْفَتْوَى لَهُ, meaning it goes out from the domain of fard kifai to the domain of fardul ain. Because if there's only one scholar in the city or the vicinity, or there's only one scholar this muqallid can access, then you need to be able to access the edict that is suitable for this person. So it will become a de facto obligation upon you as a mufti or student of knowledge or whatever. If you're learned enough and you're able to give him the hukm of Allah, then you have to. You cannot back away in that situation. In that situation, there's no humility. You have to give him the fatwa. Or her. Another question asks, when we say that maslahah should be considered for an opinion, what's the exact argument being made? Are we saying that even if the evidence indicates that opinion X is correct, we should still take opinion Y because that is where the maslahah lies? Or are we saying that maslahah is ingrained within the Sharia, so is considered an independent source of evidence? Therefore, if the maslahah is in opinion Y, then the evidence would indicate towards opinion Y. Maslahah is not an independent evidence in the Sharia. The independent evidence is the Quran, Sunnah, Ijma' and Qiyas. Maslahah is a secondary evidence like urfan, istihsan and qawl al-sahabi, which gives weight to primary evidences that contradict one another. So it balances out. It gives weight to one side over the other. So when we talk about maslahah, it's not independent evidence. It is from the murajjihat. It is a secondary evidence, especially when the alternative position is extremely hard to act upon, or if the mustafti needs the opinion that is based on his or her maslahah. Can we say that wherever the maslahah is, that is the rajih position? Maybe that's your question. Can we say that wherever the maslahah is, that is the rajih position? No, we can't. Because according to the majority of the Ahlul Sunnah, this is a theological matter. According to the majority of the Ahlul Sunnah, the haqq in Allah's eyes is one. Al-haqqu wahid. So as mujtahids must do their utmost to find out what that haqq is, what that truth is. If they err in the eyes of Allah, then they still get one reward. If they hit the target, then they get two rewards. And we'll only know of this on Qiyamah, obviously. But the point here is that if scholars differ, then there is flexibility for a mufti to pass the alternative opinion as per the maslahah, even though they might consider it to be the marjuh and not the rajih. Like Umar ibn Abdul Aziz said, that it would have made me happy if the Sahaba were united over everything. Yeah? Because if they were united over everything, then it would be consensus on every single matter. If there's consensus, there's no flexibility. And he said elsewhere that I wouldn't swap the differences of the Sahaba for any amount of money you give me, any amount of wealth. Humrin Na'am, he said, red camels, which was a highly prized possession in his time. Him speaking as a Khalifa is speaking about Humrun Na'am as the most prized possession. So that is why the scholars say اختلاف العلماء رحمة اختلافهم رحمة وإجماعهم حجة. The scholarly difference of opinion is a mercy. Mercy is not a hadith, it's a legal maxim. It's a mercy in the sense that there's flexibility for a muqallid to take whichever opinion he or she wants. Whereas the ijma' is a hujjah, the consensus is a binding proof. You cannot go against the consensus. Sheikh, are you Hanbali? No, I'm not Hanbali. Khair, are there any other more questions before we wrap it up? Khair, so Jazakallah to everyone for attending this course, who have attended this course, and if you have subscribed but you haven't finished watching your lessons, then please do finish watching them. And on Saturday the introductory course starts. It's for 8 lessons over 4 weekends. The first 2, meaning this Saturday and Sunday, they're free public access. So even if you don't intend to subscribe, please do subscribe. Please do join them on YouTube or Facebook or whatever. And can you expand upon fiqh al-aqalliyat? Fiqh al-aqalliyat basically means the fiqh of minorities. So there's default rulings for Muslims living in a Muslim majority state, but if you're a Muslim minority, if you're a Muslim living in a non-Muslim majority, so you're a Muslim minority, so in that situation there would be certain rulings or certain situations which would simply be inapplicable because of the fact that you're living in a Muslim minority. So for example, Muslim penal law, Muslim criminal law, these things wouldn't be applicable for Muslim minorities. And this is an area which is still being developed. So I mean, books have been written on it, and it's an extensive discussion. Okay. خير وصلى الله وسلم وبارك على نبينا محمد وعلى آله وصحبه أجمعين والسلام عليكم ورحمة الله وبركاته.